Mr. Chairman, honorable. My name is I.M. Ben. I appear with my learned friends, Perekeme, Perez Agar, PP Agar. We have visited with me for research. PP Agar.
This party representative. Any party representative.
No.
Yep.
Matter is adjourned for hearing today. However, they will have a pending motion. Yes. Before the tribunal.
Okay.
Yeah. The motion is to recall as sole witness. Oluwadamilare Asun. Oluwadamilare Asun or Asun.
Let's see the process. What is calling the witness name?
Oluwadamilare is OLU. So we use the
Mention the different. The two people who are in the perseverance. But I don't think it's. What else should
But it will be printed afternoon. The motion dated 19. And 5/22.
very well, sir.
The witness name is
Oluwadamilare Asun.
Yes.
I don't even know the meaning, right? I know one of the commissioner might be able to this word of knowledge.
You should have a jurisdiction. Is it not?
Yes, sir.
Winner was for the election.
Yes.
Yes. Came from Canada. Yes. Yes.
Yeah, you said the motion is to enable us to record our.
Yes, the body witness. So with the utmost permission of the tribunal, we are ready to move the motion if we can proceed, sir.
Okay. We can start with them.
Yes, we will start.
Are you present?
We are not opposed to it.
So you didn't find anything?
No, we didn't find it out.
Okay.
Because we felt like it's the same witness.
It's so witness they record.
Yes. I would have cross-examined him before. We're calling him maybe.
To clear some.
Yes. I was raised by him. All about it. So he's able to help us. Like we're looking to help us. The real one.
Yes, sir. So without them wasting the time of the tribunal, our motion is dated 19th of January 2026 and filed the 20th day of January 2026. We seek leave to move in town.
5 in B.
Also filed on the 20th of January 2026.
What are we after this?
If you're asking for a date to now, that is active before grant our application, we'll be asking for a date to be. Okay, we should actually finish.
What days?
Yeah.
Yeah.
I want to propose to. It's fast.
Let me give the early first. I thought they will just.
So we thought it was like,
Just rule and adjourn.
I'm done.
Okay.
Which is
The application of the appellant filed on the 20th January 2026 is granted as prayed, and we accordingly order as follows. A. Leave is hereby granted to the appellant to file and rely on additional witness statement from both with the accompanying documents thereto. B. The appellant is granted leave to recall his witness who had been Larry Asuni, who had earlier testified before this tribunal. And C. The additional witness statements on oaths already filed on the 20th January 2026 is hereby deemed to have been properly filed and served. Yeah, it is. That's what we done.
All right. That's the ruling granted this morning by the tribunal. And gracious, we then be asking for dates.
only
The further to the ruling granted this morning by the Honorable Tribunal, which we are gracious for. We will then be asking for dates to ensure the presence of witness.
Okay.
Yes. Mr. Chairman, I want to check.
Yeah.
I don't know if it's sick by. Adjournment stops. Stops by my learning.
Yeah.
No reasons were given. The absence of the several witnesses.
Yeah.
Secondly, precisely on Thursday last week,
What date was that?
precisely on 12th day of February,
Yeah.
I called my learned friends, both of them. Oh.
What?
Both counsel for the
Appearing now.
yes, both
Okay.
counsel for the appellant. I
Okay.
spoke to them on the phone, and I precisely asked them if the witness would be in custody, and they told me yes. Based on that fact, I left Abuja yesterday. I was at Federal Court Abuja. To participate in this year. Even though my learned friend, PPR is capable, more than capable of handling.
Yeah.
My Lord, Mr. Chairman, this process, the motion and the recalling of this witness has lingered for more than 6 months. In the circumstance, I pray that the witness will foreclose. The alternative, in the interest of justice, where the tribunal deems it fits, its wisdom, not to foreclose the witness, to asking for substantial cost.
The punitive one.
Yes, very true. Now they're asking for 1 million rand.
Yeah, the only one.
It's a big one. It's coming from Canada.
Yeah.
So that's our problem.
Has this motion, motion of the over 6 months?
6 months. Let's look.
But that's why that's one of my grounds. I don't know when my landing is going, but it's mentioned in.
And the day if my lord should check his record.
I know orally, I just had given a hint that they want to recall a witness.
Yes, when I first examined their witness, that was 6 months back.
Yes, Aziz,
I think I need to say.
Aziz, wait, you will say something. The point I want to draw your attention is, can you by consent of both of you, you have not moved on application. Can you by consent, as arranged that your witness present?
In fact, that's what I wanted to see. When he said
You don't know. I want person sit down.
what I told you was I would have a motion.
I'm addressing baby.
Okay, sir.
Can you by consent arrange that the witness must be present when the application to record that witness has not been moved? Which means you were preempting that it will be granted.
The business of the day.
Yes. You were preempting that since you are not supposed
The
to.
business of the day. I did not file a counter.
Exactly.
Yes,
Was
I
it
did not
granted?
file a counter because I know.
Must it be granted?
Yeah,
As a matter of course.
yes. I know that.
What application is not.
Now, fair hearing, I
Yes.
knew that the court to allow it because we did not find a counter.
You were
And the
preempting.
business of the day. The business of the day today is for continuation of hearing.
Remember,
Let's
my
assume.
question is,
Yes.
can two of you by consent grant the application that has not been moved in the tribunal? It means you have granted it, you presume that it will be granted.
No, my own is not for the motion. My own was for the witness appearance because I wanted us to conclude.
Well, as is, it's asking for 1 million because
Of course, we vehemently oppose. We vehemently opposing.
address issue of the cost, not leave the rest. Just how much
Not paying.
are you considering?
Just we oppose. We are considering to 0 naira by.
Is they're asking for 1 million naira.
Yes, we are considering to 0 naira every channel.
Yeah.
First thing first, my lord, this court cannot,
The tribunal.
this tribunal
Yeah.
cannot award cost based on the reason that was given by my learned friend, which is not technical in law. when there is a pending motion before the tribunal, which must first be heard and granted. Before a witness can now be asked to come back or be recalled. That motion was granted this morning by the tribunal, just some few minutes ago, or which hour. And it's practically impossible to bring a witness whose motion was also granted just now, which are gracious to the tribunal. My learned friend also misrepresented before this tribunal. I'm going to grant him the honor of not using a negative word, but just misrepresented this tribunal that this motion has been lingering for the past 6 months, which my lord will claim this is false.
Yeah.
The reason for this motion was based on the admission made by the respondent witness on the 7th of November 2025.
That's second thing is
That's the only thing that is.
obey the points you are making.
Very well. So we take the hint.
Because one of the reasons why we don't have it.
Yeah,
We just say it should address issue of
we
cost.
take the hint. So when you called, we told him there's a pending motion, and that motion needed to go first before we can call out. And that was what we told him. I don't know where we got the information that we are going to call. That aside, we are not considering the cost. We are gracious. Our witness is going to be available on the next adjourned date, based on the ruling that was just granted by the Honorable Tribunal. Our cost follows events. We came to court today, and the business of the court still went on. That was vicious.
So never from
No one, he didn't even call me. He called my landed friend, Derek. So that one gave me the. So when you called, I was able to surprise. So I spoke with him. And I think there is emotion because there is no way I can tell you a witness.
Well, those are
When the court has not granted emotion.
those are not material now.
Most of that, sir.
Maybe we cannot consider issues
motivation.
in anticipation of the application that was made to be moved to group. The application was moved this morning and we granted it.
Yes.
So if on the next day you can and they come and say they can't go on, that's office. The fact that you call and he told you,
Mr. Chairman.
wait, I'm coming. The fact that you called and he told you, yes, and he has said he told you there's a pending motion.
You know,
So except we're preempting the motion, there's no how you would have brought the witness to the tribunal preempting that the application will be granted and go on with the case.
you never can tell.
What if you came and the application was not granted? So whatever he told you that the witness will be here, I think that is
Just as a sign.
yes.
Just a void of.
I don't
He's looking at one part of my submissions.
Okay.
The other part.
The other part is that
when I cross-examined their witness,
Mm.
he rightly said he will file a motion. The next adjourned date, they never did. I didn't complain. And we keep lingering until the last adjourned date. They now file the motion. We would, in fact, would have asked for cause the last adjourned
They
date.
didn't ask.
Did they ask?
Besides, sir, what is
they-
even saying is totally false, sir.
And
So,
finally, I'm
Off
coming.
record, sir.
I'm coming. This is off record finally.
Yes.
This is off record finally. My learned friend said, I said that their witness is available. I can even swear for an oath that he said the witness will be here while I made the call. And I spoke to him directly. I first of all spoke with Noel. Okay, but I spoke to him directly. He confirmed to me, he's the one coming to court. So he confirmed that the witness will be here. So what I want him to refrain from is to accuse me as a liar.
Well, let's
Because he actually said that.
agree on the dates. Let's look at the order.
Remember, it's okay.
No, and I want them to at least know
You say
that we are not happy with their
You say it's
participation
not
of bringing
he
our-
already knows that you're.
Yeah, we need to.
Yeah,
No, I'm standing on my feet.
Please, this procedure is live.
I'm standing on my feet.
Yes, absolutely.
My pain is that I have to leave Abuja to be here. I have to leave Abuja to be here.
So you need less not have come.
I am privileged to work for government. Whether it's taxpayers' money, it's not taxpayers, that's your business.
Our money.
But I want you to step up. I want you to step up. It's not your money. It's my salary that you should have tax.
Remember, it's okay. You made your point, baby.
Maybe let's look at 19.
You want us to sway from cost, but you don't want to watch your language.
Let's look at
Watch your
19.
language.
Remember, that is okay.
No,
Let's look at 19.
My statement is, as if, yes, sir.
Can we please?
Let's look at 19.
The tribunal does not just want
Can we let this slide?
Yes, sir. All right, sir. Because my statement is 100% justified.
No,
This motion has not been
no,
taken.
Remember, I got it here.
This is live sessions.
Yes, I got it here. 19.
Let's take I think there'll be an contract for So let's take yes. So let's take 16. 16 is from 16. 17.
I mean, let's see.
So Chairman, that 16 is coming for me.
17.
16, 17, 16, 17, coming. 16, 17, 18, 19 is not coming.
Yes, sir.
You are the other. You don't know about that. You name it, not the other. Forget.
Date 17th.
Yes, sir.
The tribunal has taken note of the circumstances leading to the demand for cost, but the tribunal is not inclined to award costs now in view of the fact that the application to record the witness was moved and granted this morning. Consequently, and by consent of both parties, case is adjourned to the 17th March 2026 for the record of the appellant's witness. Then by next time, it doesn't go on, and ask for costs. Let's go on. What's next case?
Next on the course list is appeal number TAT/SSS/015/2025. Case setter Dixie Drilling Limited versus Aisha State Board of Internal Revenue.
My name is Samuel Aziz. I appear with more one for the rest, for the appellants.
Utmost respect. Chairman, my name is I.M. Deng. I appear with my name PP. Appearances for the rest of most of them. There is no appearance, representation.
Matter is that just today was compared. I know that the fact that we don't. Yes. Which was just filed this morning and still at the registry. I don't think so.
Not well.
It's not the fault. Yes, still, that's what I'm saying. Because the tribunal can confirm from
You say you filed
this morning, we joined that.
has it been filed? We intend to file or it has been filed.
Joe, fix that. Because at the end of this one. It's not a Russian now.
So what I would say is that
To see us.
we are taking steps, steps for referendum.
I'm applying to an investor.
Where did you wait to referendum? Because you could have filed online, which was, you could have filed online, you could have filed it in Lagos.
We are just here, sir.
If you file in Lagos, when you come this morning, you don't distribute the copies, when we put them in the file.
Properly limited, sir.
Or you file online.
You take the intro.
So I take you down, the case was adjourned today for hearing, and we are taking steps to further work during the registry.
Currently at the registry.
Is that what it means?
Yes, sir. So we're asking for the days for hearing so that.
No,
That makes
let's
sense.
take it right now. What I find in the redundant.
Huh?
The redundant is the what?
So the file their, so on the last adjournment, the board granted them to file their reply to their appeal. So based on.
Okay, they have filed a reply.
Yes, last.
You are not
Yeah,
reacting
they
to
filed
their,
out time, so the board granted them.
Yes,
on the
yes.
last time.
so you are not reacting to their.
Yes.
reply.
We will graciously the same day
So you need a date for.
hearing. That the witness can use the opportunity to appear in two cases simultaneously. Or consecutively. There are lots of witnesses.
And then it's really. We have any joker. You have a joker.
Even this one, you go by that price. And not it, you want to move. I got to the end of the absolute cost of my ego practice. But I only do it to make you statement to your work. That's what I mean. And not in the habits. Most of the law reports in this tribunal are most of them on the website. More than 50. Check, I never asked for it. I never asked for it.
Right, no receipts, for the new structure, paragraph 19. Explained by deed, the public states clear by humans. At least you know you are the cause of this.
Yes, we are good. However, my other friend is not asking for so I won't.
Okay, he's asking for the adjournment. Yeah. You are not present there.
No, possibility.
How about the other your friend?
Because I the one that is not
The other your friend.
very gentle.
Not that one.
No, Mr. Ojekodo.
Yes.
His parents are with him now.
He's your friend now.
Maybe we will go to hearing, Martha will come back. But now,
When you get to Port Harcourt,
I will say today, but I got is just the document. Of course, for allow.
so what's it?
Yes, sir.
As this, if you don't have your witness next time, you will know that a lot of cost.
All right, sir.
You pay a lot of cost.
All right.
And cost will not follow the grant.
It took them 4 months to find their return and never for us and for us. So we gave them.
It's your choice.
Yes, sir. Because we have a package yet too.
Consent of both parties, this case is adjourned the 17th of March 2026 for hearing.
Even
Consent
better
of both parties, this case is adjourned the 17th of March. Yes.
because maybe from the response of the witness, we might likely apply consolidation.
Okay.
Yes. So from the response of their witness, we might
Yes,
likely apply for consolidation.
We will not even get consolidation. Because one of the basis of the second suit is abuse of court process. So if you are consolidating, you are technically trying to nullify that issue of abuse of court process. So
Well, consolidation is at the discretion of the tribunal.
depending if the fact and issue are the same, however,
It's still at the discretion of the tribunal.
as the tribunal, when we get to that stage, sir, of course, sir.
I'll probably let me go to start. Police will try.
Is it part of this case?
So it's not what has been adjourned, sir. It's what has been adjourned.
Till next time.
Because
Till next time.
just I use the word, it depends on the answer of the witness.
You understand?
They are making reference to it.
Yeah.
Yes, I felt it practically.
What the next case?
The next proceedings on your No, we don't have.
Zero to eight, zero to one. Yeah.
Mr. Aziz. Mr. Aziz. Mr. Aziz. Mr. Aziz.
Yeah, 028.
Yes, madam.
Yeah. Yes,
Yes, sir.
I don't know if the tribunal can caution me.
Then you
If the tribunal can.
No, but to me, I don't know my work. Some of what it's.
you people have been, this thing is live.
He's actually childish.
Ben,
He's told me, he's telling me, from where he's seated, he's telling me I don't know my work.
Ben, this proceedings are live.
As the tribunal.
If we don't force us to report you to the NTS. Proceedings are live.
I'm very sorry.
I don't know whether the tribunal heard me saying that. No. I don't know whether the tribunal heard that. What? I don't know if the tribunal can say that. He has been here saying since.
Please.
The tribunal tried and not to allow you to respond to most of.
Yes.
Because the basis was that he said what I said was not true. Which what I said was true.
Your case has been adjourned.
I'm trying to express myself and the tribunal is saying, oh, I should do it.
It is not disrupt the tribunal.
Whatever you want to do. for the appellant.
By taking this case as two personal.
I don't know what.
Yeah, yeah.
May I please have chairman, noble members. My name is
Enjoy the exciting environment.
I think two people are in the same floor, using the same different devices. One or two, maybe in the or different floor.
Because you don't use your two different, you may pass through that times.
So that's one tablet.
You're using the phone.
Anybody ready? Go ahead.
No, sir.
Continuation of defense. Basi,
Yes, Mr. Chairman, sir. We have a motion. The motion was filed on the 16th of February 2026.
then I'll let you see it. Five way.
Was filed on the 16th of February 2026.
Later one, Sunday.
Dated 10th of February 2026.
What is it for?
Is seeking to amend the respondent's list of witness, seeking for leave to amend the respondent's list of witnesses. And order granting leave to the respondents to file additional list of witness. And to file witness statement on oath of SMO Okori.
Yeah, correct. Are you aware of the motion?
And the deeming.
Basi, yeah. Are you aware of the motion?
Yes, I got a copy of this one.
This morning,
Yes, sir.
it was filed on the 16th.
I got a copy of this one.
Jonathan,
We was exactly said we check. We started with
when was it?
said we check.
Go over.
So I give him mark.
We were given a copy this morning.
Yes,
From where it's given. They had a copy. They had a copy of posting announced this morning. What's your reaction to, are you opposing the opinion?
I'm not put that. I need to look at what they have filed.
It's not harmless.
Okay, it's something that to compare what they have in there with what they previously filed. I'm not that they started anything with it. But the application, I won't, I'm not putting the application.
If you're not opposing, so you can.
Okay, I'm not putting the application.
So what do you want to look at?
I need to look at what this file, they filed the.
The application can go on for
Yes.
the
Hearing,
hearing.
that's okay, yes,
Yeah,
yes, that's okay.
We can take the application then adjourn for defense.
Yes.
That's what I'm asking.
Yes, so the application is a complete form.
I know, so if you're not opposing the application.
No, I'm not putting the application.
Mr. Chairman, in the absence of any opposition from the appellant's counsel, may I move in terms of the motion paper and urge the Honorable Tribunal to grant the reliefs as sought.
Where's the additional witness statement? Percy,
Yes, sir.
where was the additional witness statement on both files?
On the 16th of February.
The one I'm saying here, what I'm asking is, was attached to your application. Is that the one you are talking about?
Yes, sir.
It doesn't look like you paid fees for it. Okay, so
It's the one that is attached to the application, sir.
you see this now.
But it's not an exhibit. It's the witness statement on oath.
This now. So what next after this?
Sir.
I said, what the next?
If I don't get to proceed, let's find out for me. Go on and don't.
Percy,
Well, in
is your witness ready
yes, the witness is ready, sir.
today?
Because what we've done is just to replace the name of the new witness in place of the former witness. We've not changed anything,
Is your
not
witness ready?
altered.
Your witness is ready today.
Pardon, sir?
Is your witness ready today?
Yes, sir.
Are you ready to go with the defense?
Yes, sir.
Go there. Okay, you had said they want to look
Yes,
at
I need to look at it. I'll just,
okay, so I just want to be sure that let me give the ruling then. The application filed by the respondent on the 16th of February 2026 is hereby granted as follows. A, leave is granted to the respondent to amend his list of witnesses. B, leave is also granted to the respondent to file additional list of witnesses and witness statement on oath. C, the additional list of witnesses and witness statement on oath of Eselme Okori filed on the 16th February 2026 is hereby deemed to have been properly filed and served.
The Tribunal pleases.
So, Pastor, let's have it down. So your witness is ready. Can I go there? You said?
I was telling the court process of few. I was some of this process of few minutes ago. Need time to look at what they filed before and what they have after that. To be observed.
Pastor, we'll take a date. You heard your colleague? You don't know what it is.
No.
No, those days. It's not crowded.
They're crowded. No. Except if I take it to the home, how it matter.
And that, already,
How about next? How about
19th, no, 19th, 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 and 20th. Have some potential contact that they do. That man, 18, what time? 10. You have come in before, I come in for 11.
18th. Let's see. 18th for hearing. For your defense.
is limited.
Is it 18th?
Yes.
How many cases are there?
But on that, I'm coming in a big thing.
You said from another.
Yeah.
Just to stand it down for.
Yeah, it was good. I was good. That's all.
Is Basi aware of the date?
We need to speak.
Basi,
So we check out of the school, two weeks of the.
You are muted, you are muted.
All minutes.
where
Yes, Mr. Chairman.
are you hearing us? We're talking of dates and
Yes, Mr. Chairman.
we are joining to 18th for your defense.
As the tribunal pleases.
For continuation of the case, I think. Yes. By consent of all parties, this case is adjourned to the 18th March 2026 for continuation of defense. Okay, next one.
Number 4 on the court which was in on the C80s that Bank of Private Bank PS and
Okay, 025. Appearances.
All space, I equivalent for the appellant, for the applicant.
Yeah.
May it please the chairman and noble members. I, Iene S. Ibebasi, for the respondent.
Appearance, none. Yeah, it was adjourned for ruling. This is our ruling. This ruling stems from an application dated the 14th day of October 2025, filed by the applicant's hearing. The application seeks for an order staying execution of the judgment of the tribunal delivered on the 18th of October 2025, pending the hearing and determination of the appeal lodged by the appellant at the Federal High Court against the judgment of this tribunal. The application is predicated on one ground set out on the face of the motion paper and is supported by an affidavit of 13 paragraphs and a 4-paragraph order and better affidavit filed on the 2nd of December 2025. Both affidavits of attached exhibits, and there is also a written address in support thereof. The respondents confirmed service of the said motion, but did not file a counter affidavit in opposition to the motion, as opted to leave the success or failure of the motion to the discretion of the tribunal. This tribunal has carefully considered the motion, the supporting affidavits, and written address, and is of the view that the relevant issue for determination is whether this application is meritorious and should be granted. The reasons put forward by the applicants for the grant of the application are that it is dissatisfied with the judgment of the tribunal and has filed a notice of appeal with strong and arguable grounds of appeal, and that the appellant is desirous of prosecuting the appeal expeditiously, and that the stay of execution will not prejudice the respondent. The law is settled that an application will not be granted merely for the asking simply because it is unopposed. The tribunal or courts faced with such an application must be convinced that the application ought to succeed on its merits. See the case of Abiaka and Okoji, 2004, 15 Nigeria Public Law Reports by 897 at page 522, where it was held that despite an application being uncontested, the court still has a duty to determine if the application is sustainable in law. See also Gary and another against Father and others, 2019, LPELR 48241, Court of Appeal decision. We support the principle of law that an uncontested application does not guarantee automatic success. Generally, the court of law does not make the practice of depriving the successful litigants of the fruit of his judgment, and thereby funds to which prima facie is entitled pending the determination of the appeal. It is even more pertinent in tax cases that government will always need funds to execute government policies and should not be deprived of its due revenue. The onus is always on the party applying for a stay of execution to satisfy the courts or tribunal that is entitled to the grant. In other words, the application for stay must bring out necessary and sufficient facts in its affidavit to show that it is entitled to a stay, and the discretion of the court, which must be exercised judicially and judiciously, can only be exercised on sufficient materials. Even though the respondent did not file a counter affidavit in opposition to the application, we have noted that the judgment is a money judgment, and that the applicant is not claiming that the respondent lacks the financial resources to refund the judgment debt in the event that the appeal succeeds. The current judicial attitude in determining applications for stay of execution of money judgments leans in favor of conditional stay. See the case of Pamo, Nigeria, and that on that. Sorry, I take clear. The current judicial attitude. Sorry, let me go back to it. Even though the respondent did not file a counter affidavit in opposition to the application, we have noted that the judgment is a money judgment, and that the applicant is not claiming that the respondent lacks the financial resources to refund the judgment debt in the event that the appeal succeeds. Such proof shall be contained in the face of the affidavit in support of the application or any other evidence which may be placed before the court. The applicant must ensure a full and frank disclosure, including the complete and accurate account and description of all the applicant's income, assets, interests, and properties, as well as its obligations and liabilities. That is the only way the courts can be best exercise its discretion to grant or refuse stay. See Pamol Nigeria Limited against Pillar Agric Project Limited, etc. Pages 54 to 56. Morrison Industrial PLC against CPL Industrial Limited, 2009-17 Nigeria Weekly Law Report, Part 1169 at page 119, 133 to 134. And SPDC Nigeria Limited against OK, 2006, 17 Nigeria Weekly Law Report, Part 1007, page 127. In the cases of Morrison Industrial Limited, PLC and CPL Industrial Limited and SPLC in the the court held that an order for stay of execution for a money judgment should not be granted where it has not been shown by the applicant that the respondent will be unable to refund the judgment debt in case the appeal succeeds. In the event that the applicant succeeds on appeal, there is provision for tax refund or issuance of tax credit in favor of the respondent as payment of his future tax obligations to the appellant's judgment creditor. In the face of the glaring lack of any such evidence of compliance, we hold the view that this application is not deserving of any sympathy and is liable to fail on the merits, notwithstanding the failure of the respondent to challenge them. There is no material before us to enable us to exercise our discretion in favor of the appellant as required by law. The application for stay of execution therefore lacks merits and is accordingly dismissed. So that's our review.
Mr. Chairman, we thank you for the display of judicial intelligence in the just delivered ruling. I'm grateful, sir.
Last on the cost list with appeal number 80/SLS/017/2023. Tribunal Global Services Limited versus Applied with Space Internal Revenue.
Proper this tribunal, my name is Nuruddin Aziz. I'm appearing with my learned friend, Mon Edmund, to appear for the applicants. If you can open her mouth, I say open her mouth, open her camera so that the tribunal can see her. Yes, I'll pass it.
Respondents?
May I please the chairman? May I please the chairman and noble members? My name is Siene S. Ibebasi. I appear for the respondents. Mr. Chairman, the respondent is represented by SMA Okori.
Anyone for the appellant?
Yes, we have Chioma Obi. If you can open our mic and camera.
Chioma
Obi.
Designation?
So Chioma Obi, please tell the tribunal your designation.
Good morning. My name is Chioma Obi, representing Tribunal Global Services. Thank you.
Your designation in the company, please.
Designation. Your designation, you're wrong.
I'm the finance manager for Chevron Global Services, sir.
No, it's honorable.
Thank you.
If you heard me.
Yeah, Basi, you said,
The respondent is represented by Mr. S.M. Okori.
Okay. Destination rank? Rank?
How the person talk, I'm sure talk for myself. Not to
Yes, the name is a man. What is designation?
S.M. Okori is the Director, Enforcement, Recovery, and Intelligence.
Enforcement. Just taking over from, hold on, take a look.
No.
Protection for defense, protection. Is it protection? Yeah.
Yes, Mr. Chairman. Mr. Chairman, before that, we have a motion on notice. It was filed on the 16th of February 2026. The motion is seeking for the respondent to amend the list of witness and file additional list of witness. And to file additional witness statement on oath of SMA Okori. And to deem same as proper.
Yeah, you're ready. Where is that?
Yeah, so electronically we served on Tuesday. Tuesday,
Tuesday was the
17th day of February. But we were served the hard copy this morning. But,
Who is out?
on Tuesday, 17th. Please announce this application, you are not going to be opposing to that. I'm moving some, almost of less.
Mr. Chairman, in the absence of any opposition from my learned friend, may I move in terms of the motion?
What time is it? Is it? It's pretty well. We declared it. What is?
If the tribunal can be gracious enough for tomorrow, that we can cross-examine tomorrow.
Well, I had thought we could take the witness. The witness is available.
And that's what I'm saying, if we can take from tomorrow.
The witness is available. I take him now.
The witness is available, sir. Yes, sir.
I take him now.
We were looking at tomorrow so that we can,
No.
because we are talking
I'll take him tomorrow.
tomorrow, then if we can organize the issues, we can take it. However, my challenge is the exhibits, how we can verify some of the sections.
I didn't have a. Yeah, so what's your look at? Did you hear what there is?
Yes, and that's my,
And you're supposed to upload the documents of this, so that's.
the witness can be seen.
Yes.
But on which we should be part of.
Correct.
Because there are a lot of documents, most especially those ones that were subpoenaed.
Mm. Mm. They already tendered.
Yes, we already have exhibit, but I don't think they have any exhibit. So we have our exhibit.
Pass it.
Come tomorrow.
Pass it.
Sir.
Pass it.
Yes, Mr. Chairman.
The documents you intend to tender, or you don't have any document to tender?
We don't intend to tender any further documents other than the ones that were tendered by the appellant.
Then the registry said that they ought to have uploaded the documents so that the witness can view them on the screen. So I think we should take a date.
As the tribunal pleases.
Actually, they will do that by next. And you upload them. Basi,
Two of them.
Yes, Mr. Chairman.
can you upload the documents for the next hearing? Documents you intend to use to rely on.
They are not relying.
No, they are working. The respondents.
Mr. Chairman, I think possibly next month and see
Who should
if
upload?
it should be possible for us to come down.
They are not in control. They already did that.
The short copy will be a first one. PDF file, soft copy.
So we have all the soft copy.
They will upload them before.
That's the showing.
That's what we are saying. If don't know how complicated.
Practice of definitely coming down.
No, coming down is very perfect for us.
Yeah, so I get coming down.
Any technical.
If they're coming down, there's no need to upload. So let's take a
So
step.
let's hear Basil again. Please, did you say you are coming down?
I think we can try once to come down and then have a closure to this case.
So fine.
That would be nice.
That would be great. That everything is
They started different.
no sir, no started.
Maybe this is just the estimate for them. Very much is for the nature of benefits.
May I suggest the 19th of March?
Any date I'm aligned.
19th is a Thursday.
Yeah, any date we are convenient.
Let's take it. Let's take.
So you can take the 19th for
your defense.
You can take the 19th. And possibly for this and then for Pellegrini that is coming up tomorrow.
Huh?
19th of March.
For the other case of tomorrow.
If tomorrow though, we can send in all our exhibits together. So that, because tomorrow's zone, they've commenced examination in chief. We've cross-examined.
We'll get there tomorrow.
All right, sir. It's because it's mentioning tomorrow.
We'll get there tomorrow. We'll get there tomorrow.
I think it's fine, sir. So I'm not obliged.
By consent of both parties, this case is adjourned to the 19th and 1926 for defense.
As the tribunal pleases.
Man. Yeah. Your man need agree. Your man need agree. Man.
When the motion is coming up for, I've been living for 6 months. When did I file the motion? The motion was filed this month and last month.
So we are colleagues.
So where is the